Welcome to the Unbundled Attorney Mastermind Podcast. My name is Dave Aarons, and I'm the founder and CEO of Unbundled Attorney. In this podcast, we interview our unbundled attorneys, as well as the leading experts in the industry, to identify the best practices for converting leads into paying clients and how to ethically and profitably deliver unbundled legal services and other affordable options in your practice. To learn more about how our exclusive unbundled leads can help you grow your practice, visit our website at unbundledattorney.com. All right, welcome to the Unbundled Attorney Mastermind Podcast. We are happy to be back. It's been a couple months since we last released our previous podcast episode. The decision to transition the podcast to a video podcast has taken a next level investment of time, energy, and team in order to make it happen. Obviously, we've got cameras, equipment, a backdrop, all these things. So I appreciate your patience with waiting for this next episode. Is something we're committed to making sure that we have a new episode every month for you. And so couldn't be happier to be reissuing the podcast with my man, Clay Wilkinson here. We've spent many, many years working together. He's one of the first attorneys we worked with in Texas and Dallas. So has been fielding literally thousands of leads from our company and has gone through a lot of different changes and evolutions to his practice. And so really looking forward to unpacking the chronicle of your journey and hearing about all the lessons you've learned along the way.
Happy to be here. Yeah, appreciate it.
Yeah, so really appreciate you taking the time, man. So I think what would be a really good place to start, just before we got started, we were talking a little bit about your background and that you had a little bit of a different life prior to lawyering. Maybe you could share a little bit about your initial endeavors in broadcast journalism.
Sure. Yeah, this is all very familiar to me, this whole setup. So born and raised in Dallas, went to undergraduate school and then lived for 7 years after in Washington, D.C., got a degree in broadcast journalism. As part of that, I worked at CBS News, 60 Minutes, National Public Radio, did some broadcasting for them, then worked in media relations and public relations and did a number of different projects where I was in New York and Washington and other places around the country, doing a lot of really just work day to day with newsmakers and press and government officials and that sort of stuff. And kind of eventually got to a point where, once you know how to draft a press release, set up a press conference, talk to a reporter, message things a certain way, it just got very routine for me. My grandfather on my mom's side was a judge for a number of years in Dallas. My stepfather was an attorney for a long time as well. And so I had lawyers in my family. I sort of knew what being an attorney day to day could be like. And I saw different types of attorneys just in friends and family. And I thought, this is something where with a law degree alone, you don't even have to practice law. You can do any number of different things. But if you do practice law, you can do any number of different things too. And so it appealed to me to come back home to Dallas, go to law school, and then start my legal career.
Where were you living at the time before that?
So from Dallas originally, I went to school at American University in D.C. and then was in D.C. for 11 years and then came back and have been back in Dallas now for 11 years. And
you did law school in Dallas?
I did, at SMU.
SMU?
Yep.
Okay. All right. And so take us through when you graduated law school, I believe did you go straight into working in a firm, or was that when you started were you working with Thomas? You can take us through just those initial stages.
Sure. So the funny thing is, as a way to kind of get into it, is, as you know, I only do family law now, and that's really all I've done for most of my legal career. During law school, I think the summer after my second year, I had a clerkship with a judge in Dallas, and there was a fair amount of downtime, and she would say, on your downtime, feel free to roam around the courthouse, pop in on this hearing, that hearing, see what you like, see what you don't like. And I distinctly remember going into a family court hearing. I was the only one in the courtroom except for the judge, the two attorneys, and the husband and wife who were arguing back and forth about who knows what. And it was an old courthouse, old courtroom, dim lighting. It looked like the most miserable thing I'd ever seen, and I wanted nothing to do with it. I never thought I'd ever practice it. And then here I am. So it's funny how that all develops. But I ended up graduating from law school in 2011. I got licensed that same year. I joined briefly for about 6-7 months a civil defense firm, just a regular firm that company sues a company, we defend against it. It was primarily a desk job. It was incredibly boring. It wasn't satisfying in any way because really you're just helping, company X save $1 million here, $1 million there.
Yeah.
It wasn't really doing any greater purpose, I didn't feel. Ultimately, one of my best friends from law school was a guy named Thomas Howery, who, as you know, was one of the original providing attorneys through the first version of Unbundled Attorney.
Yeah.
And just kind of decided to take a break from the civil defense environment, see if I could help him on some projects. He was doing primarily family law at the time as well, was getting leads from you back then. I think that was probably 2013 or 14 when I connected with him. And just threw some family law cases my way. I ended up
5 years ago.
5 years ago.
Yeah,
it's
baby.
crazy.
Wow.
Threw some family law cases my way, ended up really enjoying, working with people, doing important work for them, that was personally important, feeling like you're doing things that's impacting their financial situation, their relationship with their kids, even their relationships with each other. And then we just kind of grew from there. It became a partnership, literally and figuratively. We opened up a small family law firm that was called Howery and Wilkinson, that was in existence for maybe 3 years total. At our, I guess, I'm not sure if zenith is the right word, or apex or whatever, at our peak, I guess, it was him and me. We had an associate attorney, a contract attorney. We literally covered every county in the Dallas-Fort Worth area.
Yeah, you had an associate that was in Fort Worth, right?
Well, the contract attorney was in Fort Worth.
That's right.
We had an associate here in Dallas, had a bunch of office space, a couple support staff, and really we're just kind of churning and burning and doing pretty well. And then, as you know, after about 3-ish years, I got an offer to join a family law section at a very large downtown firm. And at the time, it was the sort of scenario where, in my mind at the time, I saw it as maybe a step up in my career to be surrounded by attorneys that had decades more experience than I did, be a part of a big firm environment, have the support and security that goes along with that. Of course, never having worked for a big firm before and not really knowing at that point what the downsides would be. And also frankly, the salary offer too was compelling at that point in my career, having only been maybe a 4 or 5 year attorney at that point. So I made the decision to leave the partnership, join that large firm, worked there for about a year. It was about 2 months into that year that I realized I was miserable and I made a big mistake, but you don't want to, for resume purposes and all that and bridge building, you don't want to just cut your losses after 2 months. So I stuck around for a year, and then just after about a year of being consistently miserable with the work demands, the loss of control over what clients you could help and not help, the fact that literally it was $7,500 up as far as initial retainers went, and if somebody could even offer $5,000, they wouldn't even take the case, which to me seemed ridiculous. Yeah. And then also the overbilling that would occur to justify partner salaries and profits and all the massive overhead that goes along with a big firm. I just felt like I wasn't living either the personal life I wanted to live, the professional life I wanted to live, and really contributing with the skills and experience that I developed at that point. So long story short, I ended up making a decision in May of 2017 to leave that firm, not really with any exit strategy other than, maybe I can find another place to work. Maybe I'll just go solo. At least I knew initially I'd be solo.
Do you remember that moment when you made that decision?
I did, yeah. I was talking with my wife and just saying, I can't keep doing this. I mean, I'm missing time with you. I'm missing time with the kids. The salary wasn't worth it at that point. And the total loss of control over, again, who you help and how you help them was just really dispiriting to me.
Was there a number of clients that you wanted to provide services to, but you just literally your hands were tied as far as...
Yeah, and it almost got to the point where there were a couple people that I recall that, I probably shouldn't admit this on TV or recording, but people that I would just sort of help on the side, and that I wouldn't really charge anything or just charge very minimally because they had a case where they needed help. I didn't know enough good attorneys that were affordable enough to refer them to somebody and feel confident with that. And I just said, it's better for me to help you and do it the right way, even if it's off the books, than to just send you on your way because, and leave you to the wolves, I guess. So, but yeah, there were other people that I did have to turn away, either because I didn't have the bandwidth or, they couldn't come up with $7,000 to $10,000 to retain that larger firm. So I made the decision to leave. I knew at least in the interim I had to be solo. Didn't have any support staff, didn't have anyone to help, didn't really have any source of clients at that point except for maybe the dozen or so that came with me when I left that firm. And I think, pretty soon after that, I reached back out to you. and just kind of had basically a very frank conversation with you about my evolution in my practice, the thought process that went behind my decision to join that large firm, my decision to leave the large firm. And you were gracious enough to sort of bring me back on board, help me.
I think Thomas was still working with us at the time.
Right.
And so then we had a kind of a conversation with Thomas, and he was like, I can't remember what it was. I think you were rotating in, or did you take over his leads at some point? I can't remember exactly, but I think we were still working with him. I'm not sure.
Yeah, you're right. And I'm sort of glossing over that part of it. But yeah, Thomas was still, had his own firm at that point,
right.
Basically the revised version of what he maintained after I left.
I guess I think you guys still stayed separate though. I guess that was the thing is like, did we go from you working with Thomas, and then you started working for a big firm, then you came back and worked with Thomas again?
Right.
Well, I think you guys still stayed separate that second time around, hey?
The second time around, from a practical standpoint, we stayed separate.
Yeah.
He maintained his firm. I sort of had my own thing, but we still cooperated in a logistical way, case management way, and kind of with your blessing, sort of started to split off some of the leads again.
Yes.
He was still primarily, the leads would go to his firm, and then I was there essentially as kind of a contract attorney, I guess, getting reacquainted with Unbundled and the way that you guys operate. And then also some coaching and guidance from you, initially as well.
Yeah, I'll make a quick segue just for those that don't know. It's just the way we work with Unbundled Attorney is we provide exclusive leads. And so Thomas was servicing the counties that Clay was interested in coming on board in. And so, we wouldn't just bring on a new attorney without making sure that the existing attorneys are, happy with splitting the volume, because if it's an exclusive lead, it's only going to one lawyer. Right. And so this was kind of what we worked out with Thomas. We said, hey, Thomas, we have Clay wants to come back on. Are you okay with splitting the volume? Do you want to work together? And, we had these conversations because, when you're building a firm and you're getting a high volume of clients, that requires, support staff or hiring contract lawyers or, getting infrastructure in place in order to be able to serve a high volume of clients. There's no other way to do it. And so if we were to, help you build up a firm and then just all of a sudden brought on a couple more lawyers and the volume just dropped and all these people were out of a job and so forth. So we take that really seriously. So that was kind of that transition that we worked through with you and Thomas, and it ended up working out, pretty well.
It did, yeah. And I guess, fortunately for him and for me, he made a personal decision a handful of months, I guess, after I came back in the fold to leave doing family law, to, again, with your blessing and I guess his blessing as well, sort of leave all of the leads that he was getting primarily to then with me. And he transitioned out of the family law environment more to sort of a civil litigation, more secure, in his mind environment. And then I kind of took things over from there. And I think at the time, I was exclusively Dallas and really all the other counties that he was servicing at that time, which I think are Rockwall, Collin County, maybe even Ellis County at that point. But it was 4 or 5 counties with just me.
Yeah, that's why I'm smiling, because I remember that was the next phase, because it's a high volume. I mean, Dallas is one of the highest volume counties in the entire country. So I think you were getting anywhere from 7 to 15 sometimes leads a day.
Right.
So we can certainly chronicle that a little bit as far as that process and the conversations we had around, hey man, like how do you want to approach this? Because when you're dealing with that many clients, you have to grow or make some adjustments. So can you maybe talk a little bit about that process?
Sure, yeah. So the volume then was the same that the volume was when Thomas and I had that small firm. Kind of like you said, 7 to literally sometimes a day, 15 leads that would come in. Where it's just, you feel like every 5 minutes your phone is binging with somebody that needs help. And when we were the small firm, it was great because we had somebody in Tarrant County and Fort Worth that we could farm those to. We had an associate here we could farm those to. Thomas and I could split those. We had a paralegal and assistant that could help manage the volume. When I then came back in, and after Thomas transitioned out, it's literally just me trying to handle up to 15 per day. Which very quickly, of course, you think in the beginning, well, this will be great. I'll have all these potential clients coming in. I'll make all this money. This will be fantastic. And then the tidal wave hits, and you wake up from being washed up on shore, and you realize I can't do this. And not only is it a matter of me not being capable of doing that, it's doing a disservice to the people that really do need help.
Yeah.
Because if you're, frankly, if you're just ignoring or can't properly service the people that are, hitting submit day in, day out, then you're not really doing what you're supposed to be doing. And so I reached out to you pretty quickly and I said, I appreciate the volume. I can't handle it.
Yeah.
What can we do?
Yes.
And I think again, we brought on some other provider attorneys in the area, reduced the volume, allowed me to then better serve those clients. And then again, with the other people that went through the training process, learn how to kind of provide Unbundled the way that, you think is best. It really became much more manageable. And then the quality of service that you're providing is that much better too.
Maybe we could talk through that just a little bit as far as, how we figured out the best course of action, because there's a lot of options, right? As far as, hey, you're getting a volume of clients, you're getting so much business, you can't even handle the amount of clients. It's a good problem to have, but it still has its own challenge, right? And so there was a few directions that we could have gone right there, right? Like, hey, we could hire, we could get an associate involved, you could build a firm like the one you had with Thomas, but that wasn't something you felt like you wanted to do. Maybe you can kind of talk about that conversation we had and why you felt you wanted to proceed in the direction you did at the time.
Yeah, and I will say, to your credit, one of the things that I've really come to admire and appreciate about, the company, the organization that you've created and the sort of person that you are is I can't think of another company that in a lot of ways is a for-profit company. Of course, you have the different foundation, ventures that you have and some of the nonprofit things that you're exploring into, but it's still a for-profit company whose CEO and founder is willing to invest personal time and in a lot of ways personal resources in having each of the provider attorneys succeed in the way that they want. As long as you're adhering to the mission and the principles and the goals of Unbundled Attorney. And so the conversation that we had was, again, to your point, you can do any of those things. You can scale up, you can stay solo, you can create a large firm, you can hire a bunch of different contract attorneys, never practice law and just manage that process. You can do really anything you want to do. And you made yourself available to say, whatever you want to do, I'll find a way to support that. And I just, for a variety of personal reasons, partly I'm a control freak and don't trust a whole lot of other people.
We're working on this.
We're working on that. My wife appreciates the work. But I just kind of made a personal decision to say, at least at this point in my career, I feel most comfortable. And maybe in some ways it was a reaction to feeling totally restrained and constrained by the large firm environment I had just come from, where, not only do you have to ask to do everything, you get one answer from one person and a different answer from the other person, and they sometimes don't align. And that was just very frustrating for me. So I know at the time, I really felt a desire to sort of do my own thing, be accountable only to myself, trusting myself and the quality of my work. And whether it's just inertia or whatever the case, it's sort of remained that way for the last year and a half. But I know at any point I could have called you, and we have had conversations since then about maybe moving in different directions. Maybe we can talk about that more today too. But I know whatever direction I wanted to go in, and if that changed at any point in the last year and a half, that you would be there to support that and help find a way to make it work.
Yeah, well, absolutely. I think it speaks just to the quality of the relationship and what we're doing here. I really appreciate being able to work with you. It's a privilege to find lawyers that have the same, you mentioned earlier on, like a greater purpose, a desire to serve. You literally left a full-time salary with a big full-service law firm within months or maybe a year because you just felt like you need to do the right thing. And again, about your integrity, pulled away from it. That guaranteed with, like you said, not even an exit plan, just, hey, this isn't the right thing to do. I want to serve these people. You're literally volunteering time on the side or finding ways to serve these people that the firm wouldn't. That's not usual, so it's been great. And it's the best part of what we do is we get to work with attorneys like yourself that won't settle for that kind of a life, won't settle for anything less than doing great work and also serving people in a meaningful way, and obviously giving people access to services that they otherwise wouldn't be able to afford. So we love what we're doing here, and so we're happy to support attorneys like yourself in whatever way, shape, or form that's going to take. And like, to what you're discussing here, there is a lot of different options and ways in which we can make that work. We've had attorneys like yourself that have stayed solo, and then we just brought on additional attorneys to help handle the volume where, when a lead comes in, multiple leads come in, we just, one lead goes to this attorney, then the next lead goes to the next attorney, and the next lead go to the next attorney, and then it goes back, right? So we split up the volume. Then there's the option of hiring, in-house associates or creating a partnership where, attorneys work within the firm either as partners or you're hiring them as an actual employee in the firm, right? And then you have the option where you can hire contract lawyers, right? Where you do the initial consultation, then hand that client off to that contract lawyer, and that contract lawyer handles it from start to finish. And then you have the option where you can handle a higher volume of cases yourself if you just get some support staff, right? So maybe what would be helpful is like when we look at those options, how you kind of analyzed for yourself at the time, why you went the solo route and also continued. I don't think even at that time you wanted to have any support staff or a secretary. You were straight solo, which is a lot of attorneys go that route, and it's a respectful choice. And then I think we're also making some transitions to go more the contract route as well. But what was your analysis given those options at the time? Why you go that direction as opposed to others? And I think that might help with attorneys that are in a similar position for better understanding how to make those decisions for themselves.
Yeah, it's a good question. And really, as I reflect back on it, I wish I had a better answer than this. I think I think the main reason I chose to do what I did was pure survival at that point. I mean, to your point and what I've said, I didn't have any exit strategy. I just sort of made a decision based on reaching kind of a critical mass of displeasure at the previous firm where I said, I can't do this anymore.
Yeah.
And the nature of that work at that large firm is I either had to make a decision to pull the parachute and jump ship, or spend a whole bunch of time trying to sneak around and interview at other firms and with other attorneys and try to do contract work. And I literally didn't have the time or the opportunities to kind of go down that path either. And who knows how long that would have taken. Could have taken a month, 6 months, a year, who knows. So when I made the decision to leave that firm and then again just sort of land on my feet and try to get things going in a way that would produce enough income to support me and my family and our expenses and all that, I didn't really have time or an opportunity to find a partner or hire an associate or even find a good paralegal or legal assistant that could help at that point. And I guess as time went by, I certainly could have done a lot of the standard things that people do, like hire an assistant or a secretary or, find an associate or a contract attorney to help. I just think at that point and as time went on, and the other part of it too is at that time, Thomas was still using actually the office space that we're in now. He's since vacated. I've now taken over this office space. But at that time, I didn't have an office space either. And I didn't know, in theory, am I going to find a paralegal who work from home and I'll work from home? And how do you make that work? So in my mind, there were enough kind of survival-based obstacles to me doing anything but just being purely solo at that point. And then as enough time went by and I was able to not only survive, but really thrive and do well at it, then you get to a point, well, if I can do all this and still have a personal life and not be totally burned out, why do I want to then write $3,000, $4,000, $5,000 to somebody else if I can just do the work myself and keep it myself? Now, that calculation has changed over the last several months as the volume has sort of, ebbed and flowed, and we're in a different position now than we were then because of some county shifting and things like that, which we'll talk about. But that at least was the initial analysis, for lack of a better word. It really wasn't a whole lot of analysis, but that was the thinking going into it.
Yeah, and so at the time, so you didn't have office space. So you can just talk about how you were making it work as a solo without an office space. At what point you then got the office space, and so for solos that maybe you're just coming out of law school or transitioning away from a firm, how they can maybe manage it a little bit in the meantime and kind of get their feet wet. Because I think the decisions you make were completely understandable given your situation. Coming from a firm, didn't want to deal with, managing a lot of people. Obviously, you were feeling constricted from that. And also, you didn't have office space, so you don't want to take on more overhead than you're confident that you can cover, right? And so you want to run kind of a lean ship, right, at the beginning and make sure you've got your bases covered, then make those the next steps. So could you maybe walk through, like, okay, I was a solo, I didn't have office. Take us through the steps you followed to then get the office space and maybe arrive to where we're going here. Sure.
So I think in March of 2017, so maybe 2-3 months before I decided to leave that firm, my wife and I, and this is another testament to how crazy and out of my mind potentially I was when I left that firm, we bought a new house that was sort of an upgrade on the house we had before. And one of the features of this house was I had a home office. And so it really appealed to me to actually be able to work from home as much as I could. and just kind of wake up and roll into the office and work on my own time and all that. So
less
that appealed to me.
Yeah.
Exactly. A lot less traffic. So that was part of the decision. I also, another bit of context, I guess, is when Thomas and I were still Howry and Wilkinson before I left that to join the large firm, we signed a 5-year lease on the current office space that I'm operating out of, that we're doing this broadcast from. And when I left, I still helped out from time to time with the rent. Thomas was primarily in charge of that just because he was using the space and using all the office space here in, including this conference room that we're in today. But when I came back and started going solo again, he was still here using this space. So, and I was, again, still kind of helping pay that rent. So it didn't make sense, again, like you said, from an overhead standpoint. I don't know what client's going to come in the door tomorrow. I don't know what expenses I can meet. I'm already paying this mortgage. I might as well use that primarily as my office space. And then what I started to do with him is just say, hey, from time to time, could I come back into the conference room as long as you're not using it, and use this to meet clients and potential clients. Eventually, as you know, when he transitioned out of not only family law, but out of this office space, I then kind of came in and took over. I still work from home primarily, but I do use this space to meet clients and potential clients. And I also, as you saw, sublease out the actual office space to other practicing attorneys. Now, I will say, to kind of get to your point about for people that are deciding to go solo or make that transition, how do you find space that'll work for you? Not everybody can.
Or at what point do you even make that decision? Obviously, you get a certain amount of clients. How were you doing when you're working from home? Did you meet people at coffee shops? Were you going into co-working spaces? I mean...
Yeah, so I'd met people from time to time at coffee shops, or, you know, if they had an office we could use. And I mean, inevitably, you have enough people that are like, are you really a legitimate, you know, lawyer that you're meeting me at a Starbucks in the afternoon? I mean, maybe if I was 30 years in and they're thinking, this is kind of cool that he's leaving the office to go do this, but not as somebody who looks a little bit younger and all that. It looks like I don't know what I'm doing, or don't have an established practice, which in some ways I didn't, I guess. But it just got to a point where I realized, even if for nothing more than just appearance purposes, I needed a professional place that was consistent, that people could come to and meet with me at. And it's a shame you can't see kind of the whole setup here, because it's a nice sort of wraparound conference room space with a lot of natural light and looks out on a nice highway and all that, to the extent a highway can be nice. But it's a great space to meet clients and potential clients. And again, Thomas at the time was generous enough to, you know, just be a good friend and a good former business partner and say, sure, you can use it whenever you want. And then when he transitioned out of it, then it really became my primary place to meet clients and potential clients. My situation's unique in the sense that I always sort of had that home office there as a way to just do work at home. I had this space available to meet clients and potential clients. This lease actually ends in April of 2019. And so what I've already started to looking into doing, which I would really recommend to other solos who don't have that sort of unique home office, this kind of setup, is there are a number of places like Regis from Meridian that offer kind of you can pay just a regular normal monthly fee. You can either have an actual work office space or not. But typically one of the benefits is they have a conference room like this that you can share with other attorneys. You can book it as you need it. They give you a certain package of hours. And it's a way to not have to invest a ton of overhead in an exclusive space, but have all the amenities and the things that you would need to run a successful practice. And the last thing I'll say too is, which we were commenting on before we started, with all the technology and apps and everything that exists now, you really can be a full functioning, efficient, productive solo practitioner without a whole lot of, you know, necessity for a big, sprawling office space that you own exclusively, whether it's Dropbox on your phone, Clio, Google Voice, any of the other apps, Calendly, you know, things that will help you with your practice. So I would just encourage people to be as creative as they can be about finding space, understanding there are a variety of different options out there. And then with all the technology that exists, that can only further maximize what you can get out of any particular office space.
Right. Yeah, absolutely. And we can maybe unpack some of those tools that you've implemented that have made a pretty big difference in the way in which you do every initial consultation and how you book people and all these types of things, Calendly being one of them, and practice management software. So we can do that. We'll maybe cover that towards the end. What I'd love to do is just kind of bring us up to date, because you obviously were working from this conference room. We started to explore a little bit about contract lawyers and starting to figure out a way to handle this volume, because as a business grows, you get more referrals. Obviously with our lead generation continuing to ramp up, as it does. So take us through where things are at, in the last, maybe a couple months and some of the decisions you're now making and some of the relationships you're now forging. And what was it that made you want to start to switch? I mean, obviously the volume being one of them, of course, and that might be the main one. So maybe you can tell us a little bit about what that next stage is. So, as you started running for a solo for a long time and now you're starting to consider working, getting some of the work off your plate.
Sure. So, you and I have kind of joked that the nature of the leads is it's either feast or famine in some ways. There's never a consistent sweet spot where you're like, okay, day to day, this is perfect, right? And so over the last year and a half, there have been different versions where I started out with Dallas and all these counties exclusively. I reached out to you. I said, it's too much. I can't continue to do this in a way that makes sense. I think you brought on at that point, Elise Wolfel in Collin County, who split some of the Collin leads. I think she's still there.
Yep.
There was another Dallas attorney who helped split the Dallas volume.
Yep.
I may still be exclusive in Rockwall. I can't recall. I think I didn't do Tarrant at that point because Fort Worth for my office location is a little bit too far. It didn't make sense. But it almost got to a point where, went a little bit too far, maybe in the other direction. And so I reached out to you, the last handful of months and said, I love the work that I'm able to do with the clients that come through your service. Is there a way that I could maybe expand out to Denton County, for example, which is in sort of the northwest part of the Dallas-Fort Worth area, and just kind of tinker with some of those relationships. And ultimately, it's at a point now where I may be exclusively in Denton, I think.
Yep.
Dallas, I believe, is between one provider and me. Collin, same thing. Still have Rockwall. And I'm getting probably, today was kind of nutty, as you know, but generally it's probably 4 to 6 to 7 leads per day, which for a time was great, but again, as you know, and as we talked about, it gets to a point where when the volume is okay for a while, inevitably you start to fill your plate more and more to the point where now it's at the point where somebody calls me today and I look at my calendar and I'm setting an appointment for today's Monday. I'm setting an appointment for Friday.
Yep.
Because I've got a hearing tomorrow morning, tomorrow afternoon, appointments in the morning on Wednesday, today's Monday again. Basically just booked solid because of all the work that's kind of come in the last couple months, right? And so you get to a point where you don't want to decrease the volume. You want to continue being able to help people in a way that we're committed to helping people. And so what I've been doing is reaching out to other attorneys that I know and that I trust to say, would you be willing to come on board, commit to serving people in the way that Unbundled is committed to serving people, and I'll handle kind of all the administrative, logistical stuff about billing and practice management and all that. You have the opportunity to get essentially clients handed to you. You practice law, and that's really all you do. Mm-hmm. And so the benefit of that, frankly, there's a financial incentive for me to do it because, that's passive money in my pocket, essentially.
Leveraged income, that's right.
There's a benefit to them because it's work that they can do that fits the Unbundled model. And then there's sort of the global benefit of that's more clients that are being served in the way that we're committed to as Unbundled provider attorneys. So it's really a win-win. I'm still sort of in the interview decision-making phase. Mm-hmm. I've had a number of calls over the last week or so. But it's getting to a point where, again, I think literally I've gotten about 10 leads that have come in today, and it's just now about 7:00 in the evening. I'll probably get another 1 or 2 tonight. And if I have a good call later tonight with somebody and also with the other person I spoke with this morning, they're ready to set up to take clients now, and those are people that can be served that I at this point may not even be able to serve this week that would just get passed on to who knows who at that point forward. So it's been an evolution, but a good one. Yeah.
Yeah. And so at each stage in the game, there's new decisions that have to be made. And that's just the process of building a firm. Of course, and it's not just our lead generation. The more clients you serve, the more clients they're referring you get get a reputation going and get all different kinds of sources. And at each different level, there's new challenges in order if you want to be able to continue to, like you said, be the one to serve those clients and ensure that they're receiving the types of service options that we provide. That might actually be a good point for you. Maybe if you could verbalize or share, what your vision of what Unbundled Services Commitment is, how you've integrated that into your practice, some of the service options you offer, that, when you're going to be hiring a contract lawyer, this is the types of things that these lawyers would have to want to be a part of in order to work with you and your firm.
Sure. So I think one of the stories that I told you when I was leaving that large firm and going back to being solo at the time was the story of somebody who literally had a no child, minimal property, agreed divorce that I represented, that the client was handed to me by a partner at the large firm. And I had to do a little bit of legal research on the case, draft some pleadings, eventually, walk them to court to get the divorce finalized. At my current firm, as a solo, that type of work could potentially be less than $1,000 total, maybe a little bit more, just depending. And that could be unbundled, could certainly be an hourly rate retainer deal. It just sort of depends. At that firm, I think the final bill for their case, because partners were involved, I was involved, there was overbilling that occurred on the partner's side. It ended up costing that person, I think, over $7,000 for an agreed divorce. Again, no children, no appreciable property to divide or split. Wow. And a marriage, I think, literally that was maybe a year and a half old, And I was personally put off by that, and I had to try to put on a good face to the person and justify what the costs were. But even then, I was sort of conceding, this is ridiculous, So what I see the benefit of Unbundled attorney being, and being a provider attorney as part of that is, and especially as a solo too in some ways, is when somebody contacts me and you get a sense for, even if you don't get a sense for what their income is, because frankly, it really shouldn't matter, being able to offer them a whole range of options and opportunities for, I can charge you a flat fee for this or that. I can charge you by the hour and do a regular retainer if you feel that's more appropriate. Whatever the case may be, the fact that I and other Unbundled attorneys are willing to look at any scenario and say, instead of, unless you can pay me $10,000 today, I can't help you, call somebody else. It's, what can you do?
Yep.
And how can I match my services up to what you can do in a way that makes sense for you and me?
Right.
So that's really the literal opportunity. And what I do with any initial telephone consultation, and then later when I meet somebody, if they come into the office, is run through the pros and cons of both sides of it, run through their budget and their finances and what they're comfortable spending, and then being as creative and open as I can be to meeting their goals, both on a legal side and also on a financial side.
Right.
And the last thing I'll say about it is, if anyone, and I encourage every potential client to do this, to Google my name, read my client reviews. I literally, over the course of my solo career, and when I was with Thomas at that previous firm, have never had a single person complain about a bill, about a charge, contest anything. And I've represented hundreds of people over that time. And all the reviews that you find online for me are all 5-star reviews. And it's not, I don't manipulate that. That's just what people have left. I've literally never gotten a bad review, at the risk of jinxing myself.
Yeah.
But knock on fake wood. But I think a lot of that comes from the fact that if you're willing to be creative and flexible about how you offer your services, if you're willing to meet their budget and expectations with your services, then there's never going to be a time where they feel like they're being taken advantage of or manipulated in some way, because the conversation at the very beginning starts with, what do you want? What can you afford? And how can I meet that?
Yes.
Rather than pay me $10,000 and the next thing they know, they're getting a $30,000 bill that doesn't make any sense.
Yes.
So,
right. So maybe it would be helpful if you could unpack some of those service options that maybe attorneys either have a little bit of experience using, or maybe this might be the first time that they're hearing about unbundled services, and maybe they had a traditional big full service law firm, full service retainer, and that was it. And so this could be an opportunity for them to start to explore some new different kind of options they could offer, so that they could tailor the amount of service they're providing to their budget, and be able to meet people's needs, more affordably. So maybe you could unpack a little bit about, the suite of options that you could potentially offer. And again, that's kind of evolved over the course of the years we've worked together and all the different conversations we've had. So maybe you could even start a little bit with what you started offering, and then some of the things you've developed over the years and how that's helped. So
yeah, well, I guess maybe a good way to try and explain it, and if ultimately you want some more information than this, let me know. But
sure.
a good example of it is a guy that I've told you about that I represent now fully in a divorce in Collin County that has both children and property. he started out kind of a classic scenario where he told me up front he doesn't trust attorneys. He has the money to pay a full retainer, but didn't want to necessarily do it. Felt that he was smart and diligent and productive enough that he could kind of do some work himself and research some things himself, and we could sort of be a partnership in that way. But felt more comfortable at the time, both financially and also practically, really representing himself in court. And having me do kind of on a case-by-case basis some unbundled options. So, for example, what I did for him was his case was filed, I think, in spring of this year. The judge set a very quick trial date just a couple of months after filing, and he wanted to get a continuance on the trial date, get it pushed back some, and have the judge order some other things as it relates to the case. So I charged him a relatively low flat fee to prepare the paperwork for him, file it for him, meet with him in advance of the hearing and kind of advise him, okay, you're going to go to court. Here's how you introduce this kind of evidence in Texas. Here's how you make this sort of legal argument. If you want a witness to appear, they don't want to come. Here's how you subpoena them. Here's how this particular judge likes to hear and consider certain things, and really just prepare him to go to court and be fully armed in a way that, without any sort of help, he'd be, kind of swimming without a life raft, I guess. So, and I did a number of different things for him like that, whether it was drafting discovery for him later, responding to discovery for him when it was served on him, doing some other pleadings along the way. And ultimately, he got to a point where he came to me one day and said, you've so impressed me not only with the quality of work that you've done, but the fact that you were willing to do that at first and be creative in that way, and trust that I'm not going to screw up the advice that you've given me, and trust that I can go to court and kind of execute this in a way that I think makes sense. So he came back to me and ended up hiring me fully and paying a retainer and billing by the hour, and still has continued to be impressed with how respectful I am with his time and his money and all that. So, I've got kind of in my own practice, my own sort of list of things that I offer on an unbundled basis. And I guess to further kind of clarify, I do it really one of two ways. And Texas is a difficult state, as you know, for unbundled, because most judges, if not all judges, expect that when you get on a case and your name is on the pleading and your law firm's associated with it, that you're on the case until either you go through the whole hassle of a withdrawal process, a formal withdrawal process, or the case ends. Right. So what I either have to do is do unbundled, kind of paired with a motion to withdraw and an order already signed by the client approving the withdrawal if things get out of hand and they don't want to continue to pay for it, or I stay officially out of the case and I kind of advise them and do paperwork and documentation behind the scenes.
Yes.
And that works really well. And literally, the sky's the limit as far as how far you can break down your practice into all its different components and the different services that you can offer. One thing that I'll say, and I'm happy to go into whatever detail you'd like, but one thing that I remember you telling me when we were talking about how to further break it down into all its different components is my initial pricing on that. And my thought process was, okay, if I look at how many hours it would take me to do X, I'll then multiply that by my hourly rate, and that's what I'll charge the person. And you came back to me and you said, well, that's fair, that's fine, but also recognize that there's a premium in the fact that you're offering that in a way that 9 plus out of 10 other attorneys are not going to. And so you can bump it up a little bit because you're offering them a benefit that many other attorneys are not going to.
Yes.
And ultimately, even if you do bump it up a bit, it's still far less expensive than a lot of other attorneys would charge for the same thing under a traditional expensive retainer hourly rate model. So to that point, if I was going to charge X for a pleading that would take, I think, about an hour, maybe I charge the equivalent of an hour and a half's worth of time, again, because I'm providing the benefit and the service. So that's kind of how I approach it now as far as how I price it, what I offer. And again, you can break it down as far as you want to go, as in terms of what your particular state's litigation models offer.
Yeah, maybe what would be helpful is we can unpack an example of what something you would normally look at and do the hours of, and then it is important because that we kind of flesh out this idea of like, well, is unbundled mean, okay, if something takes me 3 hours to do, then I just charge them 3 hours times my hourly rate, right? And then there is the money, what I charge, right? But the reality is, like you said, maybe 1 or 2% of attorneys on a whole are offering unbundled legal services and are willing to give someone a service in a family law case that's contested, right? That costs anywhere from $300, $400 up to $1,000. Anything less than $2,500 or $2,000, right? Even the new solos, if they're doing full representation, would be $1,500 to $2,000, right? So to be offering a service option that's $500, $700, $1,000, whatever it might be, it's such a, and I'm sure the clients respond that way, right? They're like, well, yeah, of course I can fit that in my budget. That sounds great. And if we could do this, this, and this, would that work for you? Yeah, that would work for me, man. Like, I wish I found you a long time ago, because that really isn't, and there really isn't available. And there's, obviously hundreds, if not thousands of clients out there that need that service that are otherwise going unrepresented because they just don't even have access to it, don't even know it's available, right?
Right.
And so to them, they feel very appreciative that there's even an attorney that's willing to work with them and provide them advice, help with their documents, getting them through the process at a rate that is roughly about a fifth of what most attorneys would charge as a starting retainer. And so that's a value. That's a value in the sense that you're open and willing, and also you've gone through the process to understand, okay, how do I do a limited scope retainer agreement? What are the ways in which I can structure it? What are the different service options I can provide? Like, there's a whole process to figuring out, okay, how do I deliver it, right? And then, so that's just a great benefit, just to be open and willing and figuring out, okay, what do I need to do to effectively and ethically deliver this? And so there's that piece. So that's a value to the client. And then as far as your building of it, the other piece of it is, okay, well, does it have to take me 3 hours to do it, right? Because when you're doing a traditional hourly model, is there a benefit really to becoming more efficient? Not really, right? I mean, it's just like, well, you kind of, from an integrity standpoint, yes, if I can do this faster, ought I? Yes, you probably ought to, right? You don't want to waste the client's money. And that's something obviously you believe in wholeheartedly. But, as running a for-profit business, it doesn't inherently necessarily have a benefit to do so, right? Whereas if you're offering, unbundled services on a flat rate, and let's say you do the math on it, your hourly rate's $250 an hour, usually be $750. You add in a bit of a premium, maybe you charge $850, right, or $900 for delivering the document services, advising the, whatever the package is, and we can talk about a few different ones. What if there was a way where you could, automate some of the document preparation, or you could hire a paralegal, and the value of $950 to a client is still what it is, right? They're really stoked about that, and they're receiving a service that 95%, 98% of attorneys wouldn't be able to provide them, and the only other option is they have to do it themselves. So they're obviously happy. That's a great value to the client. Now the question is, does it have to take 3 hours, right? And are there ways in which we could streamline, automate the process? As far as the things that have to happen over and over again for every family law case in every different situation, the intake procedure, the data entry of that case information into the documents. Who's going to prepare it? Are you going to review it, right? And using a paralegal support staff doesn't necessarily cost as much as if you do, right? So there's a lot of things that can be done there, where now for $950, what if we could change that to, instead of taking 3 hours, now it's 2 hours or 1 hour, right? Now the effective hourly rate starts to change. And so these are the opportunities that Unbundled presents, and rightfully so, right? Rightfully so that the attorney should benefit from that. So maybe you could talk just a little bit about, maybe give a couple of examples and maybe some things you've done to become a little more efficient now that you have, a more clear incentive to do so in ways that have worked well for you.
Sure. So the easiest example that I have of that is usually an agreed divorce scenario, where somebody comes to me and either they have children and property, or they don't have kids but property, or they don't have either, right? But they know that they've worked out all the terms with their spouse. They're both on board with the divorce. They don't want to spend a whole bunch on going to court or even mediation. And they come to me and they say, here are the terms of our agreement. Can you help me with the paperwork and ultimately going to court? In Texas, you have to show up in court at the end of the process to appear in front of the judge, run through a series of yes/no questions, have the judge grant the divorce and sign the decree. So under that scenario, what I've managed to do as a way to illustrate this is I typically charge anywhere from a flat fee of kind of on the low end, $1,000, on the high end, maybe up to $1,500. That typically includes the filing fee, which can be $300 to $350 that the county collects when you file for divorce. There's no service fee to have them literally serve, because usually they're signing a waiver. It's like a waiver divorce. And what that includes is all the paperwork from start to finish, the initial divorce petition, the divorce decree, and any closing documents, And then also my time going to court with them at the end of it to, again, prove up the divorce in front of the judge. What I do is, even though I don't have a full-time paralegal or assistant or another contract attorney at this point, I do have a virtual paralegal who works for a number of other attorneys in the area who does most of my paperwork, including initial divorce petitions and divorce decrees and closing documents. And so under that scenario, what I do is I pitch the flat fee unbundled service that's cost controlled, that's far less than a large retainer that they would pay for most other or at most other firms. And I then farm the literal work out to the virtual paralegal who literally charges me $19 an hour to do that. And of course, I review everything. And I know she's got 25 years experience doing all this. She has all the right forms. I review it as a quality control check at the end. But I say over the course of each particular agreed divorce case, maybe I spend at most an hour's worth of my attorney time reviewing documents and going to court with them. But if you're making 3 to 4 hours worth in profit, it makes a lot of sense, right? And again, to your point, they're getting good quality work that's being checked and managed by an attorney. They're getting a financial benefit and a service that gets them from start to finish without having to pay a lot more. And then on the attorney provider side, you're getting the financial benefit too of knowing that you're committing a minimal but good amount of time on something, but realizing more profit as a result of how you're handling it.
Right. Yeah, this is so important, I think, for attorneys to recognize and understand, because a lot of attorneys think, well, if you do unbundled legal services, you're helping lower income people, you're going to make less money, right? And that's like second rate, low class, and you can't build necessarily a very profitable business doing that, right? And it's a myth that we've it's been like a mission in a sense with the podcast and all these different examples to dispel, because it's just absolutely not true, right? Because you take that same client. And how long did it used to take you if you didn't have the virtual paralegal? Maybe, was it 2-3 hours, something like that, to do the same thing if you were doing it all?
Sometimes more, because I've never really taken the time to get acquainted with some of the document building software that she uses.
Yeah.
So I would literally start with a by scratch divorce decree,
yes,
which in Texas, if you have children and property, can end up being 40 to 50 to 60 pages long, and just craft the whole thing from start to finish. So sometimes those could take 5, 6, 7 hours, depending on how complicated it would be.
So I probably a lot of attorneys charge $2,000-$3,000 for that same thing.
Yep.
Right? Because they're looking at it and it's like, hey, I'm $300 an hour. It's going to take me about 6 hours. So, $1,800, $2,000, $2,500 for a little bit extra just to make sure if they're doing it as a flat rate.
Right.
Right. Okay. So now, because of the fact you've leveraged a little bit and you're doing it as a flat rate, you're charging about $1,000, $1,500 or so.
Right.
And with a virtual paralegal, how much does she usually charge for you to draft that for you? So
I'd say the total $20 to $40.
Okay,
yeah.
Cool. And so $1,000, $1,500, you put in about an hour or two, usually of your own attorney time to make sure. Does that include the consultation? Does that include the initial setup and so forth, the intake?
So I offer them one of two options. And I should sort of go into a point, because you mentioned this before, making sure that you're doing unbundled and limited scope representation ethically in a way that not only protects the client, but protects you too, right?
Yes.
Both ethically and also practically, because what you don't want is any sort of misunderstanding later in the case about what you're actually agreeing to do, and the scope of your representation. So what I offer at the outset is really two options. I can say, I'm happy to do an essentially document-based final court appearance type model where you're not getting legal advice from me, you're giving me your agreement, I'm kind of handling all the logistics to get you from start to finish and get you divorced. I can offer legal advice, I can offer a whole host of other services in the event this becomes contested and breaks down, but that's a different agreement and different compensation, right? So as you know, the two different types of things I offer any potential client that comes in the door is an initial free phone consultation, followed by a $200 paid consultation for an hour in my office if they want it. Under the agreed divorce scenario that I'm describing, for their convenience and their budget, what I say is I can email you an employment agreement that's clear, that protects you and me. I can email you an intake form that you can fill out and get back to me. Here's a website through LawPay that you can use to make your debit or credit card payment. In other words, we never have to meet. You never have to take time out of your busy day to come sit with me in my office. I don't have to take up that time, to meet with you. If you want to have an hour-long consultation and get all the advice in the world so you can then have a productive conversation with your spouse about kid issues and property issues and how to divide everything, I'm happy to. But that's the additional $200 consultation fee, right? So the point of it is that I really offer both options. They can just pay the flat fee, get divorced from start to finish. They give me their agreement. Or I can do all that plus the $200 consultation and still make some more money off that time as well.
Right. Okay. So in the event, so if they come in, they pay the extra $200, that's a separate thing. Right. But for the document preparation, for the uncontested divorce, $1,500, if they do it online, it's about an hour or two of your time roughly?
Right.
Okay. So your typical hourly rate is? $275. Okay. So your effective hourly rate when providing it this type of leveraged, unbundled document services for the uncontested divorce. So it's about an hour or two of time. You're collecting about $1,500. That's about $1,000 to about $750. Well, if it's $1,000, so it'd be $500 to $750 an hour, right?
Right.
So it's almost 2 or 3 times that to deliver a service that 95% of other lawyers wouldn't necessarily deliver at that price point. But your effective hourly rate is 2 or 3 times what you would normally make on a full service retainer of $10,000 up front.
Right.
Right. And are there a lot of clients that would be pretty happy to receive services for these rates? I mean, yeah, of course there is, right? So it's an entirely new way of looking at the marketplace and so forth that has worked well. But this is a really easy example, right? It's an uncontested divorce. I mean, any attorney can do an uncontested divorce unbundled. I would like to talk about a contested issue because a lot of attorneys won't look at a contested. Maybe we could cover, ethics and in doing this unbundled services or these types of options. Texas being one of the most conservative states, we're going to have a number of attorneys coming on the podcast in Texas because we're doing kind of a Texas swing. So we're going to be talking about this a lot, but maybe, we mentioned that briefly, like how do you protect yourself? How do you make sure? Let's talk about contested. And you, just like that client you gave it as an example, he was dealing with a contested matter. You're helping him with pleadings, you're doing responses, you're advising. How would you go about delivering, unbundled services within that frame, both protecting your firm as well and for the client's sake?
Sure. So from my perspective, what I try to do, again, to protect the client, to protect me, to make sure there's no miscommunication or ambiguity going forward, is to be very clear in a written employment agreement right at the outset of exactly what I'm agreeing to do and also what I'm not agreeing to do.
Yes, right.
You have to be abundantly clear, even if you feel like it's going to put them off, as far as saying, I'm not doing this, I'm not doing that, I'm not, blah, blah, blah. It just behooves you, again, on both sides of it, for you to be totally clear about what the employment agreement actually is. And also feeling totally comfortable if they start trying to take advantage of it at some point down the road and ping you with this or want to know this or want you to do that for extra for free, respecting yourself in your practice and saying, I'm happy to do whatever you'd like me to do, but I'll remind you that the employment agreement said X. And so Either we stick with that or I'm happy to prepare a new subsequent agreement that covers what you'd like me to do.
Yes.
So
setting boundaries, in other words, from the outset, and also enforcing the boundaries, right? Courteously and respectfully, but this is the line that was drawn. We were clear on this line at the beginning. And if you'd like me to step, you're obviously open and willing to provide the services, but this is the original agreement. Let's create a new one, right? Let's modify our current limited scope retainer agreement, right?
Right. And I would say out of the people that have come to me and said, can you do X? And maybe don't think about offering something additional for that. And then I come back and I say, well, I'm happy to, but it would cost X, Y, and Z. 9 times out of 10, they pay for that additional service because they want it. And again, the cost is still reasonable, it's affordable, and why wouldn't they? So, but that's what I do at the very beginning is I craft a very specific employment agreement that has all the standard language in there that all my full retainer agreements have, all the basics that you want. But it's very clear about, for a flat fee of X, I'm agreeing to do A, B, and C.
Yes. And
then I'm not agreeing to do whatever else that most commonly may come with representation. Like, for example, if it is the behind-the-scenes representation, then I'm not agreeing to become attorney of record in the case. Or if I am attorney of record and the case goes in a direction where certain things happen that you either can't or don't want to pay for, then you're agreeing to have me submit this agreed motion in order for withdrawal so that I can efficiently get out of the case. And ultimately, look, I mean, if they've paid for things that haven't happened yet, but the case sort of goes off the rails and they can't or don't want to pay for you to continue to stay on under that model, then maybe you do refund some of the money, to be respectful and ethical of their time and their money too. But the point of all that is you really have to think through and be careful about being clear about what the relationship is at the outset, because it only creates problems down the road if you don't.
Yes. And what we're talking about here is the two planes of unbundling, which Anthony Sanders, when we were at the retreat, obviously unpacked this, in depth, but I don't think we really talked about it that much on the podcast. So, horizontal plane being a timeline of what's going to happen in the case, as far as, initial petition, then the hearing, then if it becomes contested, it can go these different ways. And it's basically like a fork, like a tree of possibilities, right, of what could happen, right? And it could remain uncontested, or it could go uncontested and they could not respond, or they could submit a response to that with additional terms or something. And then you need to go to a hearing. And if that doesn't, then you go to mediation. If that doesn't work, right, there's all these different possibilities. And so you can help someone on the horizontal plane for A to this point, but then if it doesn't go this way, then we'd have to come up with a new agreement, right? So you can limit the scope of involvement on the horizontal plane and provide unbundled services in the sense from I can do it from here to here, but if this scenario happens, then we need a new agreement, right? Because if this scenario happens, it becomes contested, or this thing happens, then we might need to go to trial, or we might have to do something that's way more complex, right? And so you don't necessarily have to make a decision of I need to provide for representation from A to Z in all scenarios, which would be the traditional form, right? You can cover some of the contingencies and offer something that's more affordable as long as you've been able to create an agreement with the client that says, if these things happen, then we would need a new agreement, or otherwise I would have to be off. And that's why I can extend this flat rate that is going to be a lot more affordable. And it can fit in your budget, right? We cover the contingencies on the horizontal plane. And then you have the vertical plane, right? Which is at each phase of these steps, there's going to be a number of services that need to be performed. Who's going to provide these services? Are you going, if the client is empowered to do some of the work themselves, then that obviously is going to reduce the amount of billable time for that specific segment. So you've got, if we're looking at just the segment of B to C, okay, well, there's all these services that need to be done. If I do all of them for you, then it's going to cost just the usual hourly rate of me doing all the work for you. But let's say if you file the documents, you prepare these things, you complete these questionnaires, or you do the XYZ, or you go to court and I just advise you, and then you actually try to do the mediation yourself, right? You don't have to pay me to do those pieces of it. You don't have to pay me to go to mediation. That's going to reduce the cost, right? And so it creates a much more creative and solution-oriented thinking about how you can get someone from A to Z. Because what happens most often when clients is they'll start a case, they'll kind of jump in the water and start helping them, and then the person runs out of money and then basically is left there to drown, right? But if you can look it backwards and say, well, maybe we should have limited the scope earlier and looked at the realistic budget of the client and not start on a pathway that ultimately the client could not afford to bring to fruition from the outset, right?
Right.
So it's these two planes that all of a sudden you can start to think on and put into the employment agreement that makes sure that you can, there's a meeting of the minds between you and the client on what you're providing, what you're not, at what phases. And then if you have these assurances in the agreement and you have that agreement with the client, it gives you a lot more flexibility to be able to craft something that's going to be a lot more tailored to their budget.
Right.
Is there a way you could give an example of just to make it a little more real, like a contested case of, well, I could offer this option, I could offer this, I could offer this, here would be different price points. That's a little bit challenging, but could we think of how you might think through ways in which you could help someone if they come to you with a contested custody matter or a visitation, certainly within the contested realm, of different ways you could go depending on where people are at financially, right?
Sure, yeah. So I guess a good example that comes to mind is there's a person who went through a divorce about a year ago, and mother of two children, wife in the divorce, obviously, at the time sort of went has a bunch of family money, has some personal money too, and based on nothing than sort of prestige and reputation, went with one of the largest firms in the Dallas-Fort Worth area, who inevitably had a paralegal billing on her case, an associate attorney billing on her case, and a supervising partner billing on her case, where the effective hourly rate she was paying, when you add all three of those up, is anywhere from $700 to $950, right? And I want to say spent $50,000 plus on a divorce that lasted less than a year, that didn't really have a whole lot more than a hearing or two in mediation, right? I don't even think they did discovery at any point. So she came to me after that whole process, and without getting into the details of the case and really what the issue was, there was just one sort of minor contested issue that the now mom and dad have a fundamental disagreement on, that their divorce decree itself didn't really cover or plan for. So she said, I'm so burned by that experience with the endless retainer, endless invoices and billing, the overbilling that occurred. Can you come up with some flat fees and some limited scope ideas that will help me manage this case in a way that where you're fully representing me, I'm getting that benefit, but also helps me feel like I have some security and control. over how the cost goes. Because again, she felt totally out of control.
Yes.
And just bled to death at the previous firm. So I said, absolutely. You know, it's what I do. It's what I've done for a number of years. And so at each phase of the case, and the case, I've been representing her fully from start to now, and it's still going forward, is at each phase of it, I just sit down and I say, okay, here's what you want to have happen next. How can I best get you there? And what can I charge you for that? Again, that respects my right and ability to make a living as an attorney, and also give you the control and the security that you want on the financial side of things. So to break it down even further, what we had to do initially was what we had to do initially was go to mediation before we could even file anything. So that was easy. I just charged her a flat fee to propose mediation, go to mediation, and handle that from start to finish. That's easy because that's one contained event. Okay,
so then you create an agreement. I'm going to do these services for this phase. And that was it at that point, right?
Correct. So what I literally did, because again, and I can see how some attorneys that are not familiar with this concept may look at it and go, that's going to take me forever to sit down and think about, you know, what are all the different things that I can do in my practice, all the scenarios that can come up. What would I charge for each of those? How would I manage all that? But really, that's no different than having a potential client come in and sit with you and say, here's my case. What direction could that case go in? In your mind, you're thinking, well, you may go to mediation, you may have to do discovery, you may have to have a hearing. It's the same analysis, right? Mm-hmm. It's just that under Unbundled, you're assigning a price point to each of those events that you would still talk through with a client, right? So it's the total same analysis that you would do.
And it's the same events that are going to occur with client after client after client, right? So it's just a matter of taking the time once, right? And really figuring out how long does it take me and what would be involved there.
Right. And again, it's all the things that inherently you learn how to do as an attorney under any sort of state litigation model. Here are all the tools and options available to you. You know all that if you've practiced for even a year or two at this point. So I sat down with her and I said, okay, for mediation, I will charge you a flat fee of X. I can't recall what it was, but I'll charge you a flat fee of X. I think I may have even broken the fee down into saying, you pay this amount. If we go to mediation and he doesn't show up, then I only keep, say, half of it.
Okay.
You know, because at that point, we're not spending the full day there. It's still a lost opportunity from a business perspective for me because I'm carving out some portion of that day, right?
Yes.
And I'm preparing and I'm going, but it's not fair for me to keep 100% of it if I'm not spending the whole day there. If he does show up, then I am entitled to keep the full percentage, you know, and then we go from there. So you try to be creative and flexible about respecting their budget, respecting your time, making them feel like you're hearing their concerns and addressing them on the financial side of things. But that's what that agreement looked like. I'm agreeing to go to mediation, set it up, and then we'll figure out what the ultimate keep is depending on what happens at mediation.
Okay.
In that particular scenario, he did show up. We went to mediation, had a full session. I kept 100% of the fee. We didn't settle. And then we had to file and set a temporary orders hearing after that. So I then came up with basically a fee for that, filing the modification, having him served, paying the fee, and then covering my time preparing for and executing a temporary orders hearing. What then happened about a month?
New agreement?
New agreement, totally new agreement.
Okay, yeah.
Totally new agreement that she signed and I signed and kept on file separate and apart from the initial agreement.
Okay.
Also separate payment. Between filing the modification and the hearing, that side sort of unexpectedly served discovery. And discovery, as I'm sure most, if not every attorney knows, is where you can request documents or answers or information from the other side in anticipation or preparation for a hearing. So they served discovery. And at the time, I actually couldn't recall if our agreement covered discovery or not. So I went back and looked at the agreement, and it did not cover discovery. So I reached out to her and I said, again, politely, they've done this. We now have 30 days to respond pursuant to the rules. I'm happy to respond, and I kind of have to, but here's the fee that I would charge for that because it wasn't contained in our original agreement. And she goes, absolutely. She paid the fee, and then I got right to work responding to the discovery. So kind of to your point about vertical and horizontal, something popped up that wasn't anticipated, but because I still offered the security and the flexibility of another limited scope thing. And again, we crafted a new agreement for that discovery that was the third agreement now with a third compensation model. Then it proceeded like that. Just to finish the point, the hearing came and went. The case still goes on. We're now on our fourth agreement as we move toward us serving discovery and then moving toward a final trial. So it's taken on different aspects along the way. But again, I've made financially as much, if not potentially more, doing it that model, as long as you're, again, respectful of the boundaries that you set, not giving away your time for free, and coming up with a price point that makes sense based on your experience and your time too.
Right. Hey, yeah, exactly. And also if you're doing each step as a flat rate, you can build in a little buffer in the fact that you're open and willing to offer this that otherwise attorneys wouldn't. You're not just taking a big time retainer up front. You're willing to work with her one phase at a time. That's a huge value. And then you can build in the margins of efficiency that help with each phase in the process. So more than likely, you probably would be making more on these than if you were just doing them, full rep, I just bill you, that kind of thing, right? That if those things are in place. Let's run the scenario that let's just suppose that she didn't want you to do the 30-day, but you're attorney of record at this point, or not, right? So let's say she didn't want to respond to that, or she didn't want to pay you for that. How does it work, right? Like, have you come across that? I mean, I know that doesn't happen very often, right? Where they're like, you're working with them unbundled, and then all of a sudden they're like, well, no, I don't want you to do that part. I want to do it myself, right? Like,
it's a good question. I will say, truthfully, I've not had a scenario where something has happened where you have to do something in response to it, like discovery, and the person just flat out couldn't pay for it, couldn't afford it. I mean, I guess if I have to think, maybe there's been a time or two where somebody says, look, I'll pay you over time for that total cost, but I can't come up with all that now under that 30-day time frame.
Sure.
Maybe they're stretched then to that point. And I'm usually happy to do that because if at that point they paid for every previous agreement, I trust them at that point. They trust me. I'm willing to give them a little bit of leeway at that point and say, sure, pay that out over time. I know you're good for it. I know you'll get there. I'm not going to risk you being sanctioned or literally legally hurt in the case because I can't, I'm not willing to take anything but 100% today.
Sure.
So you just be a little bit more flexible with them at that point if you need to be.
And there's a bit of a tick for tack there, right? I mean, it really needs to be, as far as like, hey, there might be a scenario in which they need something done and you're doing things one phase at a time, and you maybe say, okay, pay that over time, or maybe something that happens there. But you've got all these margins of efficiency. I think that's the piece that a lot of attorneys also don't take into account is like, how many more clients could you be providing services for if you weren't just offering 5,000 or 10,000 to start, right? I remember when we were at the retreat and I said, think about all these different clients. How many of them would you have actually been working for? Would you have actually been able to help if you had been requiring 5,000 up front and doing this? And like all the hands went down, right? It's just, and when we talk about, attorneys adapting and how many clients they would have had before, it's like 5 to 10 times more clients that they otherwise would be turning away. Right. And so there's this huge upside of opportunity cost. And then an attorney might go, well, in that case, I might have had to do that for free or not get it paid up front. It's like, yeah. And that, unfortunately, I think what happens is it's really easy to become a stigma, right? Like, oh, I didn't get paid for that piece of it. I don't know if I want to do this anymore, right? Or, we talk about payment plans. A lot of attorneys almost all of our attorneys offer payment plans. And they look at the one client that didn't pay them and they did some work and got, ahead of the billing, and then they got burned on that one, right? And it's like, darn, I got burned. I don't want to do that ever again, right? Without necessarily looking at it from a strictly business perspective and go, well, look, I've brought on 50 more clients that I otherwise would have if I'd been rigid with this this month, right? Or in the last 6 months, 50 more, right? This one client of those 50 burned me, which is the actual numbers. And we really look at it, and I've interviewed a lot of attorneys on this podcast. It's like 1 out of 50, right? 1 out of 45, maybe, something like that. It's like 5% burn you on the payment plan, right? But there's all those clients that you otherwise wouldn't have been able to serve, and you wouldn't have collected any money on. And when you look at advertising ROI, you're spending money on a billboard, you're spending money on bringing clients in, lead generation, whatever it might be, or on your website and SEO and all these different things. You want to make sure every call that comes in, you're monetizing, right? And so it's so easy, I think, to look at it and go, oh, well, that was a loss there. But it isn't a loss, right, overall, when we really look at it, right?
Right. And to further, I guess, reinforce that point, and what you mentioned a moment ago is when you do the hourly rate, traditional retainer model, which, I mean, again, you're not against necessarily. Some cases are better suited for that. Some people are willing to, pay that and have you represent them that way, and they prefer that. The point of this, of course, is to offer the whole spectrum of options and try to make, your services fit what they really want, what their goals are. But even under the hourly rate retainer model, to your point, it's a one-to-one benefit for the attorney, right? You charge by the hour. And if you're billing ethically, of course. I mean, if you're padding it and overbilling, well, that's not ethical. That's not the point. But if you're like me and other provider attorneys that are being ethical, it's a one-to-one benefit. You do 1 hour's worth of work, you get paid for that hour.
Yes.
Under Unbundled, you can spend less time and make even more.
Yes.
Right?
Right.
And then you have the benefit of once the money is paid, it's there.
Yes.
You're not overbilling and chasing an invoice that you're lucky if they ever pay, and spending quality billable time trying to catch money that may or may not ever get paid.
Yes.
Right. So there's a number of benefits that flow from this model. The other part that I also should mention too, from a protection standpoint, and I want to follow it up with the thought that I am flexible about this, of course, because you don't want to be this rigid. But on most of the unbundled services that I do, I at least put into the contract the notion that once you make the payment, whatever it is, that it's non-refundable.
Yes.
Because what you don't want to do is create this scenario where, they want to quibble about this or that, or they don't like the outcome of the case or something, and they want to start demanding a refund, right? So you want to be clear at the beginning that it's a lost opportunity for me business-wise if I take your case and commit that time. Also, typically, once the work is done, I've already expended the time doing the work, and so you get paid for the work that you do. You don't get paid for the outcome, right? And if people balk at it, which most people don't, then I typically say, well, you're welcome to research me, read my standing with the bar, read my client reviews, get a sense of how I work and how I operate, make sure that I am trustworthy and ethical. And also, the reality is, truthfully, at the end of the day, if somebody really had a problem with something, or if I made a big mistake, I'm not going to risk my law license and my reputation for a couple $100. I'll either give them back half or some portion of it, or the whole thing if I really messed up, and acknowledge that. But I also think, again, to set boundaries and to set expectations, they're paying for the work that you're providing, not for the outcome, right?
Yes.
And so I think you want to make it clear, to the extent you're comfortable, saying, when you pay this, for all these reasons, it's non-refundable at that point,
right?
And again, that locks in the profit that you're making, and further reinforces the financial benefit of doing things in an unbundled way.
Well, that means that you don't have an account receivable or outstanding receivables,
right?
And from my understanding, I think account receivables for a traditional firm is like 70-80%, or maybe it's the other way around. 20% or something like that. They don't collect.
Right. So to give you an example, at the last firm that I was at, I think they had a collection rate of maybe 65 to 75%. And again, part of that is under the theory that you bill $20,000 on an invoice, knowing that really you've padded a third of that, so that if they pay half of the third, it's bonus money, right? Whereas for me, whether it's unbundled or even hourly rate retainer, literally I've got about a 97, 98% collection rate.
Wow.
where I'm not spending valuable time chasing down money or invoices or trying to harass people, which again, it leads to the next thing, right? It increases client confidence in you.
Mm-hmm.
It increases referrals to you.
Yes.
It increases good reviews and a good web presence. It increases the amount of time that you have to provide good services to people and make money that way. So you're right. I mean, it's money in the bank that you don't have to spend chasing, and then it has all those other benefits too.
Right. Exactly. So I would be remiss if we didn't touch a little bit on technology, because things have evolved a little bit for you. Maybe talk briefly about Calendly, a little bit of practice management software, and just how you've been able to build those efficiencies in. Obviously, the virtual paralegal being a great find. Maybe you can talk about how you found her and settled on a virtual paralegal. Because obviously, if you're going to start doing a lot more unbundled services on a flat rate or pay as you go, one task at a time, it presents the opportunity. Like, how can we become more efficient? How can we find ways to get these things done in faster periods of time? Because then it's only going to increase your effective hourly rate at each phase of the process in a contested case, or if you're doing each individual case as a flat rate. So what are some of the things that you've done to build in these efficiencies like we've talked about?
Sure. So I guess I'll walk it through from an initial lead coming in and kind of how that goes over the course of a case if they hire me in some way. And the caveat that I'll give is I'm not the most technically savvy or proficient person in the world. So certainly I could be doing a lot more, but I think what I do is very easy that anyone else could do and also really benefits the practice. So here's the point ultimately. As a lead comes in, as you know, through Unbundled, you have the option to receive an email, a text message, really whatever form of communication you want. So I have the whole, range. As soon as somebody hits submit through Unbundled, I get the email, I get a text message on my phone. For my business phone line, I just use my cell phone, but I have Google Voice, right? So the text message comes through Google Voice. I have a voicemail set up, so if people call that number, it has a professional business-sounding voicemail. If I happen to be busy either in court or mediation or some other commitment where I can't call them within the first 5 minutes, which as you know is critical to
Yes.
Converting those leads, then I text them and I email them in the first 5 minutes. And that's where Calendly comes in.
Mm-hmm.
And just to be clear, it's spelled Calendly.
Yeah, calendar, but drop the ER and just put LY, yeah.
Right, calendly.com. And the great thing about that service is it's web-based. I think it costs me literally $15 a month. And what I use it for are the 15-minute initial phone consultations that I do, and also the paid hour-long in-office consultations. So if somebody contacts me through Unbundled, I get the text message, I text them and I say, my name is Clay Wilkinson, I'm a family lawyer, you found me through Unbundled Attorney, I can't talk right now, but I wanted to reach out. To schedule a time to speak with me, please visit this website. And then I copy and paste the 15-minute phone consult from Calendly into the text message and into the email. So hopefully either way, they're getting it. And I swear 8 to 9 times out of 10, I check my email within a few minutes and they've booked a Calendly telephone consultation. And the way that it literally works is it syncs up to whatever calendar you use. I happen to use Google Calendar. It syncs up to that. And so it automatically knows the days and times that not only am I available, but that I want to be available for something like that.
Yes.
So you can make yourself available 24 hours a day if you want. You can make yourself available for, certain days during Monday through Friday, or certain hours each day.
Or Mondays, Wednesdays, and Fridays from 2 to 6, right? And there's all these different windows that they can choose from, right?
Yeah, and you can include your own websites in the confirmation email that they get, that they get once they book something. You can include questions that they have to answer as they're filling out their appointment. And I would certainly encourage anybody who listens to this to go check it out and see how you can use it in your practice. But that's one way where it used to be before Calendly that I'd be in a meeting or a conference or a mediation or a hearing, somebody comes through, and then 6 hours later when I'm able to call them, they've long since either forgotten about me or moved on to somebody else or even hired somebody else.
Yes.
Whereas if they actually have a firm time, they know they're going to speak with an attorney, they tend to kind of hold off until they get the chance to speak with you.
Yep.
Because they're also getting the message through Unbundled that this is somebody who handles things differently than other attorneys. So why would I continue to search for somebody who's going to make me pay a $5,000 to $10,000 retainer if I've got this guy who either later today or tomorrow or even the next day I can speak with and
at a time that's convenient for them, because when the way Calendar looks is you can see all the times that the attorney's available, and then which you've specified in your calendar. And if you have a conflict, it doesn't show up, right? Like if you've got a trial at that time, then that as you book things in your calendar, it is also removed from Calendly. So there isn't a conflict, right? So that's constantly updating, and it looks at Google Calendar. Is there already an entry there? Yes, no. If there is already an entry there, then it doesn't show that option to the client, right? So they're choosing at their own convenience, but also can only select times that you are still available in your calendar and that you've specified that you choose to be available, right?
Right. And even further, what you can do, especially on the ones where they're booking it themselves without any real input from you, is you can say, for example, I don't want anybody to be able to book a back-to-back-to-back phone consult, 3 different people back-to-back-to-back. So I want a 15-minute buffer between each of those. You can set it up that way too. You can also set it up so that at various times before the meeting, they're getting a text message reminder of it, an email reminder of it, 24 hours before, an hour before, whatever the case may be. So it is literally one of the best tools that I've implemented in my practice to make sure that from initial contact to possible hiring, that you're helping foster the conversion, right? So Calendly is great. On the flip side of that, as far as the actual in-office consultation, what I do if I speak with them after or during the phone consult is I offer that option. If they want to come in for that paid consultation, what I do is I say, okay, I've got you on the phone right now. Let's find a day and time that works for you and me. And then I go to the website myself at that point and literally input all their information and book it myself so that I don't leave it up to them to hopefully do it on their time. I take care of it myself. And then what I also make sure to do is as soon as I hit submit on the Calendly side, I say, can you check your phone right now? Make sure you got the confirmation email. Make sure it got directly to you. Because another feature of Calendly, not only do they get that confirmation email, which is important because it has all your address and contact information, your websites, etc., but they have the ability.
Because you've configured that confirmation email to be like, here's the attorney's office information, here's his website, here's more information, read his reviews. Like you can do this, you've crafted this like custom email so they can do their research in the meantime and just get more clear about who you are, what you do, and learn more about you and all that stuff. So they're going to get all that info.
Right. And the other part of that email too, which I point out to them, because again, you want to be respectful of your time as an attorney and not have a bunch of no-shows and all that. So I say in that email, you have the option if you need to cancel or reschedule. And there's a link in the website or in the email that you can do that. So that again, they click on that if they need to, something comes up, doctor's appointment, emergency, whatever, they can go back to the website through that email, see the subsequent days and times I'm available, and then rebook if they need to, right? So it's very self-sufficient. I've had plenty of people do that, and it's better than me because I work primarily from home, as you know. I just meet with clients in this office space. It's better than me coming to the office and they're not here and I'm wondering where they are if they have that option. So Calendly's been great on both the phone consult and the in-person consultation as well. The other things that I use are pretty basic. There's a practice management software called Clio, CLIO, which I've used for years. It's always been great. It continues to improve. I'm not all that familiar with Lexicata, although for those that are, it's my understanding that Clio recently purchased Lexicata and is going to be integrating in some way. I also use Dropbox for all of my case files and things related to the practice of running my business. And then again, I basically run my practice from either my laptop at home or my iPhone. And I, as you know, as we've talked about kind of personally off the broadcast, I travel, as much as I can. And it's very easy for me on my iPhone to run a full law practice if I'm out of town using Calendly and Clio and Dropbox and Google Voice and all that.
Yeah, so it's taking the calls, setting up the links. You've already got the template email. It's ready to go. It's all kind of configured in Calendly so you can book the appointments just fine. You can look up people's case records just by going in and logging into Clio and taking a look at what's going on. You can make notes and all that.
Yeah. And also, again, from time to time, people say, like, if I'm out of town, they want to do an hour-long consult with me, but I'm not back for another couple days, and they really want to meet with me then, I'm okay with spending that time at that point. Even something as simple as WhatsApp. You can do a video conference with them. They can pay the fee for the consult online, send them a LawPay link. You carve out an hour of your day, you do a phone consult, and then they hire you a couple days later when you get back in town.
Yes.
So there's a variety of different ways that, even 5, 10, 15 years ago was just not available that allows you to be self-sufficient and productive and profitable now with all those options.
Yeah, it's really exciting. I mean, it's we're definitely in a new age as far as the types of tools that are available. You can go to a legal conference right now and there's just lines of vendors providing all different kinds of suites of services and software to make your life more efficient, and also to make it a lot easier for clients to move forward and retain you. Right? I mean, it's just, and now with LawPay, it's just a click of a button. Here, make your payment. You send a Calendly. They just click a button. If they want to reschedule, they can just do it right there right off their phone as well. So they don't have to call in your office. You don't have to pay someone to answer that call. It's kind of a hassle for them to have to do that. So it makes it easy. They can sign a retainer agreement. All that kind of stuff. So the whole process of practicing becomes, can be a lot more efficient. And then that obviously gives you the capacity to deliver these services more efficiently, less time. And obviously that's really conducive for unbundling and these types of things that we're talking about. So it's almost like they really have to go together, right? We still have a lot of lawyers that are pretty old school. I think I shouldn't mention, but Jerry, I don't know if he listens to this, but Jerry Sylvia, I don't think I think he has his sports staff print out all of his emails for him and then does it all in paper and stuff. So you can do it belly to belly. You can do it hour by hour, right? So It doesn't have to be super tech, but there are all these tools that you can take advantage of that make things a lot more efficient, a lot more effective, and help you keep up with the volume of clients that continues to pour on every day. So thank you for your thoughts there. Before we wrap up, I guess what we could cover is just, we've worked together for 5-6 years now. We've had a good, quite the journey. Anything you look back on that were important lessons that you learned, or anything that would be worthy of mention, just given your experience of working with thousands of leads? You can take it any direction you want, but just anything that you think would be valuable to share that just comes from, the many years of working with clients in the way you do.
I guess the thing that comes to mind is, as a family law litigator in Texas, I'm in court easily at least 3, 4, 5 times a week, sometimes 7, 8, 9 times a week in different hearings in different counties. And it doesn't matter what county you're in, inevitably, your hearings get set along or at the same time with other cases, 7, 8 other cases, right? And anywhere from a third to half of those cases are self-represented litigants, usually on both sides. 2 pro se people having to fight about money and debt and kids and protective orders and all sorts of things. And inevitably, you not only see judges get frustrated with that experience, you see people not getting the results that you could provide them if they either knew about Unbundled, approached you about Unbundled, had more people that offered Unbundled services. And so the lesson I think that I've learned is, if you're willing to be creative and flexible and offer a full suite of options, Unbundled, full representation, a combination of all of that, you're able to reach a lot more people than otherwise would be able to get legal services and hopefully get a better outcome. And I think even studies have shown that, and I can't remember if this was reinforced at the retreat that we had in March, or maybe I saw this somewhere else, but I think it was at the retreat that somebody presented and talked about a study that showed that if you have representation through a proceeding.
Oh, it was Woody. That's right.
Right. That if you have representation at a proceeding, then the outcome is infinitely better in your favor than if you didn't. And through Unbundled, you're able to, it doesn't have to be full representation start to finish. My clients see a value, even if they represent themselves, in still getting good advice based on years of experience and good quality, work throughout the years, to then go armed in to court on their own with a lot more information and knowledge and wisdom than if they were going it totally alone. So the point of all that is, what I see Unbundled being able to offer, and why I'm so proud to be a part of it, is you're helping a lot more people than otherwise would be able to afford these types of things on some of truly the most important things in their lives: their children, their money, their financial freedom if it involves debt, those sorts of things. And for the other areas that you serve, immigration, that's, what can be more important than your right to live in a certain place and be employed and stay there. So it's a great service. I'm happy and thrilled to continue to be a part of it. And I'm just pleased that, this has come along and able to help the people in the way that it has.
Yeah. Well, I can't agree with you more. As these years have gone by, it's been just a privilege to work with an attorney like yourself and the hundreds of others that we work with that are committed to serving clients in this way. And it feels really good to know that you can do you can be in alignment with a greater purpose. You can serve people in this way and also have that be something where you can do really well financially at the same, right? Like, it always feels like in the past, you'd have to, provide pro bono services or volunteer and all this kind of stuff. And, that it's good things to do and it makes you feel good, but you don't necessarily benefit as well, right? And so I think the beauty of this is that there's a, tremendous amount of people that need this service. There's ways in which you can, there's obviously more and more attorneys that are open and willing to offer it, that are getting the education through the podcast and through some of the national trainings that have been going on that Forrest Woody Mosen has been hosting, which I would encourage anyone that watches this to follow his work and some of the webinars he's doing and the trainings. We're considering putting together an online CLE for attorneys to learn, the nuts and bolts of unbundled services from start to finish on how to implement all these strategies from, in depth and so forth. Is that once you have the skill set and knowledge to know how to do this, that you can help all these people that would otherwise not receive help, but also make really good money too. It's a win-win for you and the client, and that's wonderful to see that.
Can I reinforce that point? Because I think it is a critical point for people that are listening to this to understand that, of course, there's the feel-good component about the work that you're doing, the services you're offering, expanding that access to people that otherwise couldn't afford it. But it's not just the feel-good component that, that ultimately drives us. There's, to illustrate the point without being gauche, right? When I worked with Thomas at the firm that we co-owned, gauche.
I haven't heard that word before.
In other words, I don't want to, go into what I make because it's, I don't know how appropriate that is in this particular forum. But to illustrate the point, at the small firm that Thomas and I co-owned when we first kind of got on board with Unbundled, I made a certain amount. When I then joined the large firm, my salary doubled at that firm, and that to me again was a clear reason why. Let's at least see what it's like. There was the financial incentive. Leaving that firm and now being on my own and offering a healthy mix of unbundled services and full representation, I now literally make double what I made at the large firm. So I've gone from one to then double by working for myself and offering a whole mix and suite of unbundled options. So for all those out there that say, well, why would I do that? Because it sounds cut rate or discount or pro bono or this or that. I'm here to personally testify that there is a great financial incentive. Again, if you respect your own boundaries, if you're clear from the beginning, if you set the price points at the right way, that it can be a great financial benefit to you as well.
Yes. And I think, and if you have a commitment to want to contribute and make a difference in people's lives and give access to services that people could otherwise afford. I mean, I think that's where most lawyers that go to law school, before they start out, they want to help people, because their father was a lawyer or their grandfather was a lawyer or they were helped by an attorney. And, unfortunately they get into certain, oftentimes you get into certain environments or areas of practice where it's not so much about contribution and making a difference and stuff. And so maybe that spark's been lost, but I think a lot of lawyers have that spark, but, and if you do, and that's been one of the reasons you went to law school, this is certainly an opportunity to rehydrate or reinvigorate that spark, and still be able to make, an excellent living than, most partners that are, associates at a law firm may be able to make even more. Right. So, and that's great to hear. So with that, we'll wrap up this episode with Clay. It's been a real privilege, like I said, to sit next with you and to continue to work with you in the way that we have for the years we have. Couldn't be more excited about the future and what's to come, both with the development of your practice now that, we're talking about expanding it up a bit and getting some contract lawyers on and of course, continue to work with you on that to, help it evolve phase by phase and step by step to expand the vision of the Wilkinson Empire and gleefully too, because that just means that more and more people are going to get served in the way that you embody. So that makes us really stoked. And also, of course, all the things that we're working on with our for benefit launch and serving even more people than we otherwise have that need access to the services that can't afford it. So, and to you as well, thank you so much for listening and being a part of this podcast. Once again, I want to apologize for not having an episode out for almost 2 months now. And it is a testament to the fact that we had to make an investment in, the gear and the equipment and the time of our videographers and so forth to make this happen. This is a full production effort here, obviously, with lights, cameras, and action, right? So, and obviously our time to travel and come in person to Mr. Wilkins' office here and many other attorneys as well. So, but now that we have it all in place, it's something we're committed to continuing and being very consistent with from now on. So we'll be releasing a new episode every single month, and at times maybe more, but that's something we're committed to going forward. And we're on a trip right now to film a bunch more so that we can stand behind that commitment. So we appreciate you being part of everything that we're doing here and implementing these service options in your practice. Certainly follow the show on YouTube if you want to watch in person. That's youtube.com/unbundled attorney. You can see all the episodes that we've done in video format like this. Or of course you can subscribe to the podcast through whichever way you listen on Stitcher. We're now on Spotify as well. So you can find Unbundled Attorney Mastermind Podcast through the Spotify app. And of course on iTunes through Apple Podcasts and Google Play. So plug in, learn these practices, implement them, share how it's working. We have a blog where you can share some of the things that you've done, and we'll be continuing to develop things that can continue to support you and educate you on how to implement these options in the way that Clay has as well. So with that, thanks again, Clay, for taking the time to join us today, and thank you for participating. We'll see you all in the next episode. For more information about how our exclusive Unbundled leads can help you grow your practice, visit our website at unbundledattorney.com. You can watch each new episode of the podcast on the Unbundled Attorney YouTube channel, or if you prefer to listen, you can find us on iTunes or your favorite podcast app. And be sure to subscribe so you get each new episode as soon as it's available. And remember to leave us your review on iTunes. We read each and every one of them and really appreciate your support of the show. Once again, thanks for listening.